failure to pay rent is always a red flag. And insofar as the indicator goes, if the money is not in your account by the due date, you as a landlord have to take steps immediately. Yes, life happens. Sometimes a tenant has sincere and truthful issues that may have resulted in them not paying rent. The problem that we've experienced in the past, twofold. Number one, it's a behavior. What we've seen in the past is that a tenant that gets away without paying rent once may actually do it multiple times, because now there's an acceptance of this behavior. And this is a behavioral thing. If somebody gets away with something, you'll find that it happens more frequently, or the extent, the lateness, as an example, becomes greater and greater. So that's obviously one behavior that a landlord has to stop, especially if a landlord has predetermined payments that go off their account. They don't want to wait for the money to come in before their bond goes off, because that causes cash flow issues. So that's the first aspect. The second aspect is if you are so inclined to give a tenant an indulgence for having failed to pay rent once, as an example, I'm not saying don't give the tenant the indulgence, but the reality is the notice that goes out advising the tenant of the breach of the agreement still gives them 20 business days in order to rectify that breach. So from my standpoint, I don't see why the notice can't go out on the first day after default. It is, by all intents and purposes, an indulgence. It still affords them 20 business days. Why would a landlord not send out that notice, afford them time, only to risk a situation where they've given them 2 weeks, the rent hasn't been paid, and only then the notice goes out, because now you've just lost 2 weeks. And unfortunately, it's easy to say, no, but I mean, it's only a couple of days, it's only a week, it's only 2 weeks. But we've seen from experience that somehow things get out of hand, and 1 week becomes 2, 2 weeks becomes 4, and landlords approach us 3 months later, still having not sent out the notice. So my opinion is that notice needs to go out. If the tenant communicates with you and says, no, but listen, please afford me time, the answer should be, well, the time has been afforded. You have the 20 business days to pay. The notice is administratively necessary. It's our policy. And the landlord's entitled to have his policies. I mean, he's a business. He's running a business. It's our policy. We have to do it. I've been advised by my attorneys to always send out this notice. But if you do pay within the 20 business days, no worries. What I would advise, though, is don't allow that notice to then also be taken advantage of, because it has happened on occasion where now suddenly people become serial late payers, and that notice simply goes out every month. In fact, the notice acts as a reminder to the tenant to pay rent sometimes, where notice goes out, tenant goes, the demand came through, let me quickly pay. Obviously, that's also something you want to avoid, because that goes back to that first point about behavior and conditioning behavior. So I wouldn't let that notice be taken advantage of. There are mechanisms to put into place that say that if a person is breaching a lease agreement serially or consistently, that other steps can actually be taken to say, well, that's it. You've done it a number of times. By virtue of having done it a number of times, we're entitled to cancel the lease. So you just kind of change the wording of the letter to say that this is the last time that he's going to be paying late. If it ever happens again, the lease is going to be cancelled summarily without any further notice, because you do need to control that behavior. So again, don't let month go after month after month after month where those notices go out and they're technically ignored. So you want to grant an indulgence, grant it once, grant it twice. More than that, again, you're being taken advantage of.